Mr. Harden, I am going to take your suggestion into consideration on exhibits if time is spent from your side.
Thank you very much.
Okay. This time, opening statement by the managers.
Mr. Presiding Officer, the Attorney General would like to be heard on one housekeeping matter before that.
Yes?
The Attorney General seeks a ruling from this court that to the extent privileges, attorney-client privilege, executive privilege, etc., may apply, those are held by the Attorney General. Now, we're not asking the court to rule that any particular statement or any particular document is privileged at this time, but for purposes of the manager's opening statement and going forward in this case, we ask that this court rule that those privileges, which all attached during the time at which the Attorney General was the actual acting, serving, duly elected Attorney General, attached to him. There were conversations he had with his subordinates, conversations involved with other parties, where he was the client seeking legal advice from subordinates and essentially directing his official functions. And to the extent that those are implicated, we seek a ruling from this court initially that those privileges, if they exist at all, belong to the Attorney General.
So it looks like they have a little pre-opening argument housekeeping going on. Brandon, can you talk us through what that's about?
In effect, I think they're asking that the discussion between the Attorney General and any other subordinate is essentially going to be off limits because it's attorney-client privilege. And if that's the case, then it's going to be harder for them to develop a group of evidence that might be used against the Attorney General in these proceedings.
The Lieutenant Governor obviously acting as the presiding officer in these proceedings. Talk us through the woman to his left, our right on screen, Lena Myers.
Mr. Harden, do you have a response?
Yes, Your Honor. I do want the record to reflect, in light of the court's earlier analogy to a criminal case, I want the record to reflect that the Attorney General apparently is not here. Maybe he's coming at some time today, but I think if we're going to talk about this analogously being a criminal case, that the defendant ought to be ordered to appear throughout this just as everyone else. That's number one. But number two is we're prepared to address this issue. There is a motion to, I think one of the third parties had a motion on the attorney-client issue that they were trying to raise. But I would have thought we would have dealt with this before now, just as we were getting ready to do opening statements. They've known they had this issue all along. If the court wants to hear argument on it now, Mr. Garber was always prepared to do it on our side. We'll be glad to engage in argument, but I think it's totally discretionary to the court as you're ready to proceed.
And under the rule, the Attorney General Paxton was required to be here addressing that first point throughout the trial. I'm still thinking of your motion.
So it's a bombshell there.
Yeah, so Brandon Rittenhouse, what do you make of that?
It's a good question. He should be there. I think that's part of the rules and the expectation from the court.
What can we read between the lines there, that the defendant, the Attorney General, is not here for opening arguments in his trial?
This is the tip of the spear. This is really the key part of the
I want
defense.
to clarify, under, I believe it was Resolution 36, he was required to be here today, but not all day. So let me clarify that. Yes.
So what would the advantage to Mr. Paxton be?
As per the rule, he was here at 9 as required. I didn't see anything else in the rule that required him to be here any other time.
You're right, correct.